This is an international law case, Montier versus Hall, presented by myself, Stacy Corwin, ATE 3515, Legal and Ethical Issues in Veterinary Technology. This was a civil claims appeal, and it was brought before the Alberta Court of Queen's Bench, and it was decided on January 23rd, 2002. The judge presiding over the case was Judge Lee J., and the attorneys for the appellant was P.G. Lister and the respondent A.A. Robinson. The respondents were Larry and Marjorie Hall, and the appellant was Sylvie Montier. So some facts about the original case. Mr. and Mrs. Hall purchased a black Belgium sheepdog from Mrs. Montier for $100. The Halls did sign a contract with Mrs. Montier, and that contract was written by her. This puppy was ultimately euthanized at 4 months old due to some hereditary defects, and the Halls spent about $840 in veterinary bills in an attempt to save her. She had some recurrent bladder infections, but she also had some pathological fractures that were from osteoporosis, which was believed to be from congenital defects and some nutritional deficiencies. The documents that were used to decide this case was the contract that was written by Mrs. Montier and the Fair Trading Act. The court ruled in favor of the plaintiff for the recovery of the veterinary expenses and the court fee of $25, which totaled $865. There were 3 statements in the contract that the court looked at to help make their determination. One of them discussed dogs as sold as show quality. That statement reads that all show quality dogs are guaranteed free from hereditary defects and temperament faults, and those faults could be extreme shyness or viciousness, and any other disqualifying faults under the present breed standard. Should the dog demonstrate any of these by the age of 25 months, the vendor will replace the dog with a puppy born from the next available litter. The next part that they looked at was a similar statement to the dogs that were sold as show quality, and it was dogs sold as pet quality. And that statement reads that the vendor will guarantee against serious hereditary illness or disease, including but not limited to epilepsy, until the above dog is 25 months of age. If this dog must be euthanized within 25 months of age, for this reason the vendor will replace the dog with a puppy born from the next available litter. Full veterinary documentation regarding the health conditions is required in all cases. The vendor retains the right to have a veterinarian of his choice examine the dog at the vendor's expense. And then the last area that they looked at of the contract was the simple statement that says, at no time will the vendor refund any money. So the Fair Trading Act was the other document that they used, and there was a statement in there that says that it is unfair practice for a supplier to include in a consumer transaction terms or conditions that are harsh, oppressive, or excessively one-sided. And furthermore, going into the Fair Trading Act, it states that if the consumer and the supplier enter into a consumer transaction and a provision of the document is ambiguous, the provision must be interpreted against the supplier or licensee, as the case may be. So Mrs. Montier appealed the aforementioned judgment, which brings us to this case. She and her attorneys argued that the contract was very clear. It did have that statement that said that at no time she would refund any money. The only course of action was a replacement puppy when it was available. She also felt that she should have limited liability based on the signed contract because of that statement that she made. She felt like the puppy was the only thing that the Halls should get, that there should be no monetary compensation whatsoever. And the attorneys compared the sale to a retail sale in a shopping mall. Their argument was if something was lost or was not usable anymore, you couldn't go back to the store and demand more money than what you actually paid for it. So the decision for this appeal was upheld. It was determined that the contract was one-sided and ambiguous under the Fair Trade Act. The ambiguous part was in the two long statements that was read earlier that dealt with puppies being sold for show quality and puppies being sold for pet quality. It did talk about in both of those statements that the puppy should be 25 months of age and younger. Under the pet quality statement, though, it talked about veterinary exams and documentation. It says that there should not be any reimbursement in the contract, but it's kind of not clear whether that's for veterinary expenses or if it's for a puppy or if it's from both. And so because there was that discussion about veterinary documentation, who is supposed to pay for these veterinary expenses that were incurred? The judge also discussed that it was not the equivalent of a mall transaction. This was something of that was a much greater magnitude. This was a puppy's life. This is a puppy that needed medical care, that had some painful conditions. She did have the pathological fractures. So this was definitely different. I do think this decision is fair. Like the judge said, there were no statements or exclusions. There was nothing to imply that refunds for veterinary services would not be given. There was only the discussion about giving another puppy in the event that there were hereditary defects, as stated in the contract. But again, as I stated earlier, there was also discussion in that contract about veterinary documentation. So obviously veterinary interpretation of what was going on with this puppy needed to happen, but who was going to pay for that? It did say that Mrs. Montier could get another veterinarian to look at her dog at her expense, but there's no discussion about her not refunding any money for veterinary expenses that were incurred from the purchaser. It just talked about replacing the puppy. The Halls did try to help this pup. She did receive veterinary care as necessary for her conditions. There were multiple antibiotics. The necropsy was done, and that's how they found the osteoporosis. So that's how they determined that this was a hereditary condition. This wasn't just a sick puppy. And another thing to consider, would the Halls actually want another puppy from this same breeder? I mean, obviously there is definitely headache at trying to get the money reimbursed to them for the veterinary expenses. So do they want to deal with her anymore after this? I mean, the right thing to do probably would at least meet the Halls halfway. But another thing is this next puppy that they would get, that puppy would probably be from the same type of bloodlines as this puppy. So do they want to get another sick puppy? I also feel like the attorneys comparing this incident to a mall transaction, it was not fair. You're comparing an inanimate object to a living being. Definitely left a little bit of a distaste in my mouth when I heard that. And here are my references. Montier versus Hall. This is the docket number for the Alberta Court of Queen's Bench for January 23rd, 2002. And then the other document that was mentioned in this case, the Fair Trade Act for Province of Alberta, Canada. Thank you for listening.